So now, yeah, so we have a couple folks have jumped in for attendees. So. Hello, Mayor.
Hello, everybody.
Hi, Mary. Would you like me to take down this boards and commission training, and you can?
Oh, I'm just going to say a hello. I have to get off to go to a school committee meeting. So.
Okay. Should we wait till 6 and then we'll be okay?
Yep.
Okay. All right, I'll stop this and then you can go ahead, Mayor. Here we go.
Okay. Good evening, everybody. Thank you for being here for this session. And I just want to give a big thank you for everything you do for the city throughout the year. The volunteers are the backbone of the city. The volunteer boards and commission members are a vital part. There's just there's very little we can do. Let me rephrase that. We can't do as much with our paid staff as we can do with our volunteer staff. And you guys keep the wheels of the city going day in and day out. And I appreciate it. And I hope you enjoyed today's session. It's very important that we're all up to speed on what the responsibilities are of our board members. And I guess that's all I have. And I apologize. I have to jump off to go to a school committee meeting, but you're in good hands with Ryan and Suzanne. So good night to all.
Thank you, Mayor. All right, thank you everybody for coming to the meeting. I appreciate it. I see we have a pretty good attendance. It's 46 people, so that is great. I want to echo what the mayor has said, is to thank you for your service to the city of Gloucester. Really, the city works as well as it does and is such a vibrant community because of everything that the volunteers for boards and commissions do. And I know that sometimes it can feel like maybe a thankless endeavor, but it is really important and people appreciate it. And one of the things that this training is going to do is we are going to cover 4 topics. One is understanding your role as a member of a board or commission, and that's also understanding your responsibilities. We'll also cover the open meeting law, the public records law, and the state ethics law. I'm going to save questions for the end. If you have any questions at the end, we'll have a session for that. And if you have specific questions relevant to your board or commission at the end, you can always feel free to give me a call or send me an email and set up a time to discuss that specific question. So as I said before, performing your role as a board or commission member is really critical to the city of Gloucester. Most of the boards and commissions, we are either serving 2 separate roles, right? One is an advisory and one is a regulatory. And typically the regulatory boards and commissions are performing a statutory duty that's laid out in the general laws. The advisory boards, most of them, their duties and their jurisdiction are going to be contained in the code of ordinances. As a board or commission member, it's important for you to understand what your role is, what your jurisdiction is of the board or commission, and familiarize yourself with that so that you can be an effective and efficient member of the boards and commissions. One of the most important things to do before you can do anything really is you get appointed by the mayor, confirmed by the city council, and then you must be sworn in at the city clerk's office before you can actively participate as a board or commission member. And I know that some members, you may have difficulty getting to the city clerk's office when the times are open, but the city hall is open later on a Thursday night. So it's important that everybody go in and take your oath of office to be able to participate. When you're sworn in, you're also going to be given a copy of the open meeting law or guide to the open meeting law and the state ethics law, and you'll have to sign an acknowledgement that you've received that, and that will be kept on file at the city clerk's office. So overall, for just generally on how a meeting is conducted, it's important that we have certain rules of procedure so that we can that the board or commission meeting can be conducted in an efficient manner. And typically what people rely on Robert's Rules of Order, and this may be very basic to some of you, but I'm just going to review it so that everybody is on the same page. And I know there's a number of new members that have been recently appointed to boards and commissions. So I think this, hopefully you'll find this helpful. And this is just a general overview. It's there's no requirement that you stick to the Robert's Rules of Order, but essentially what it is every meeting has to have an agenda, and that agenda is created by the mayor. At a meeting, the chair runs the meeting, right? So the chair recognizes members to speak, and only you're supposed to wait your turn to speak until you're recognized by the chair. You stay on the topic of the agenda. And then the proposal or the agenda item is discussed, and one member will make a motion, And I've given you sort of the language for that. Generally, may it please the chair that I move that the commission or board approve, recommend, right, attend, create, you have take any type of action that's within your jurisdiction on the matter before you. Another member seconds that motion, and then the chair states the motion. And once that is stated, that begins the discussion. And then once all members have participated, then the chair will ask for a vote on the motion. That's sort of the general overview. It's a good way to have a meeting conducted. It ensures orderly and efficient time, which everybody appreciates. The one thing to keep in mind is that as a member of a board or commission, you're subject to the open meeting law, and that means that the meetings are open to the public. And the open meeting law states that any member of the public can create an audio or video recording of the meeting. They have to inform the chair, and they have to, they can't be disruptive about it. So if you are meeting in a room, right, physically, then anybody can come in, they can take a audio or video of that. They let the chair know, but that is acceptable as long as it's not disruptive to the meeting. So the most important law that boards and commissions are charged with, or should understand, is the open meeting law. And that I've given you the site to that. That's chapter 30A, sections 18 through 25. And the Mass Gov website, Open Meeting Law, has a great guide to the open meeting law and lots of information that if you have some general questions that you need to have answered, it wouldn't hurt to just browse that website and see if any of your questions can be resolved. So compliance with the open meeting law is really important. One of the things that it's always important to keep in mind is that we're trying to have the most open and transparent government, right? You're a board and commission member, you're representing the residents of Gloucester. You want all the business of the government to be open and transparent. And the way we do that is comply with the open meeting law. You're going to receive the materials from the city clerk's office that tells you specific details. But the basic framework of the open meeting law is that all meetings have to be publicly posted 48 hours in advance. The public has to have real-time access to the meeting. Before COVID, you had to be in an accessible building so that the public could attend a meeting. Since COVID, there's been changes to the open meeting law, which everybody's aware of at this point. And the meetings can take place remotely, but the public has to have real-time access to that meeting. That means to be able to hear and see that meeting. The open meeting law pertains to meetings of quorums of public bodies. And when any quorum of a public body deliberates over matters that are within their jurisdiction, that has to that meeting and that deliberation has to be in compliance with the open meeting law. The type of notice that's required is the agenda must be posted, which is anything that the chair reasonably anticipates that the public body will discuss at the meeting. That has to be listed on the agenda, has to be posted 48 hours before the meeting. And the city has a process through the city clerk's office where the city clerk's office works with the boards and commissions and they do the posting for you. So it gets posted at City Hall and it also gets posted on the city website. And there's a particular template to use with the city clerks at the city clerk's website and also an email address. The city clerk has asked, and I included this information for you, is that once you use that email address to post your agenda, you may send it to all members of your board or commission, but that email address shouldn't be used to have any types of discussion about the agenda, but that's purely to be used to send the agenda to the city clerk's office. The city clerk, once the agenda is sent to the clerk and posted, the clerk does not have any control over that agenda any longer. That's up to the chair to make those corrections. And if any members have any concerns about an agenda that's been posted, then reach out to your chair and the chair will go in and make those changes. Or you can have that discussion with the chair on that. The clerk also asks that when you're submitting an agenda that you put in the subject that the please post the name and the name of the committee and the date of the meeting. So that will give them notice of what you're asking them to do. Because one of the things to keep in mind is if you don't comply with the notice requirements of the open meeting law, it's not posted in time, an item isn't on the agenda that you're intending to discuss, you can't hold that meeting. And then you have to wait for the 48 hours notice. And that happens a number of times, you know, due to inadvertence and people busy with their lives. And sometimes that happens, and it can be a frustrating process for everybody involved. So if you can work to comply with the city clerk's request about getting that agenda posted, that would be really helpful. So just to go over the basics as to what is a public body. So a public body is a multi-member board or commission created to serve a public purpose. This also includes subcommittees of public bodies, and a subcommittee is created by a vote of the board when the board appoints members to a subcommittee. Those subcommittees are also have to comply with the open meeting law. Committees that are appointed by a constitutional officer, that would be the mayor. If it's a non-public body that creates the committee, then that committee is not subject to the open meeting law. But once a committee or a board is created by ordinance or by statute, then that committee is subject to the open meeting law. The open meeting law pertains to deliberations. So deliberations are discussions amongst members, quorums of a public body about matters within their jurisdiction. That means so there's a couple of ways that a deliberation can happen. What it's supposed to happen is it's supposed to happen at the open meeting, at a publicly noticed public meeting where the public has access to it. There's always the risk that members of a board or commission would communicate with each other, communicate with one member regarding a matter that's before the commission, and then communicate with another member and relate their prior communications. So that would constitute a deliberation. That's called the serial communication, and that is not allowed under the open meeting law. So you want to make sure that if something's on your agenda, save all the conversations amongst members until you get to that open meeting. You don't want to be having telephone calls with your colleagues about matters. This is also true in some rare instances. A board or a commission will attend another board or commission because it's a subject matter that is of interest to that board or commission. And if the members of the one commission attend a board meeting of another commission and represent themselves as attending as a member and have a conversation about that with other members at that meeting, that can also be an open meeting law violation. So in instances like that, and it may happen under some topic that is of public concern, of a large interest to members of the community. So if there's a risk of that happening, it's best to also notice the meeting, notice two meetings at the same time, or just save, if you're not holding the meeting, then you save that for your own public meeting so that you don't risk a violation of the open meeting law. As you all know, remote participation in public meetings is allowed. It's allowed, the law has been extended till March 30th, 2025. The quorum of a public body doesn't have to be physically present in a physical location, but the public must be provided real-time access by remote means. And you know that we have a system within the city of Gloucester that we have the Zoom meetings that are recorded and that the public has access to, and that's compliant with the open meeting law. The law also allows for the public body to meet physically without having the public able to attend at the physical meeting, as long as access is provided through a remote means. It also allows the public body to meet in a physical location, some of the members of a public body to meet in a physical location, other members to participate remotely, and have the members participate or attend physically and not provide that remote access to the public, because what you've done is you've provided access to the public at that physical location. So there is a number of different manners in which we are able to meet the requirements of the open meeting law now. And this is to provide, there's in some instances, it provides more people access because they can participate remotely, and others they can attend physically at the location that the meeting is held. Now, in some instances, the board or commission can go into executive session. There's only 10 specific reasons to go into executive session, and those are listed in the open meeting law. And most instances, the only reason, or the most, I guess, common reason for a board or commission to go into executive session is because one of the reasons is that in order to discuss strategy with regard to litigation, and this is really pertaining more to regulatory boards like your zoning board, planning board, conservation commission. If that is one of the stated purposes under the open meeting law, the chair has to make a declaration at the meeting stating what is the reason you're going into executive session. There's going to be a roll call vote, and then the chair states whether or not the board will adjourn from executive session or return to open session, so that we don't have people waiting for you to come back and you come back just to adjourn. In all instances, to go in and to come out of executive session, any vote must be taken by roll call vote and recorded. The minutes and any information discussed at executive session are confidential and should not be discussed with anyone outside of that executive session. Also, any documents that are provided during an executive session, they should be gathered at the end and kept in a confidential matter until the reason for going to executive session has ended. And what I would say is if a board or commission is considering going into executive session, and you have any question at all as to whether or not you meet the requirements of the law to do that, you can always feel free to give me a call. There's also an assistant general counsel, Chris Brosnahan. He's also available to help you with any questions you have. So one of another topic of interest that most boards and commissions have is public participation in meetings. As you know, when you're holding a public meeting, there's no obligation to have the public members who are not a part of the public body participate in the discussions at the meeting. If you're doing the work of your board or commission that you're charged with and you have your items listed on the agenda, then that's typically what you do at a meeting, as opposed to have the public speak at those meetings. If you do determine that you're going to have the public speak at those meetings, you can do it in a couple of ways, right? You can have on your agenda that you're going to have an open comment or a comment period. Or the chair's discretion can allow the public to speak on certain items listed on the agenda. There's a recent case called Barron versus Calenda, which discussed issues about free speech at open meetings. And one of the things that the court said is it struck down a town's civility code. The court essentially said that when the public speaks at a public meeting, you can't control the content of their speech. You can control that to the extent that they have to address the item that listed on the agenda that they're talking about, but you can't control their viewpoint. So as much as people can get up and say that they love the work of the board or commission, they can also get up and say they don't like it and they're not happy with the board and commission. And you cannot, as a chair or a board, stop that. But what you can do, and it's important for everybody for the boards and commissions to do, if you have an open comment time period, is set the time limitations for speakers and set the time limitations at an open comment period and say, we're going to give you 1 minute, 2 minutes, and we're going to time it and we're going to enforce it. And you enforce it uniformly. You make sure every single person who speaks during an open comment period is given that 2 minute time limit, or whatever limit that you determine is appropriate, but 2 minutes is pretty typical, regardless of what the person is saying. Obviously, there's no First Amendment right to use profanity, and there's no First Amendment right to use fighting words that would incite people to violence or fighting. If the chair is going to allow speakers to speak during an item on the agenda, then the chair should ask that person to only address that item on the agenda, and also before allowing the public to speak, to also set a time limitation. And this just helps run an efficient meeting. It lets make sure that everybody's treated the same way. Everybody gets to have their say. And it provides people, if you do have that open comment period, it provides them with their ability to address the board or commission. One of the things that's important to note is if you do have an open comment period and people ask questions, or they say, you know, they're talking about something that a board member wants to respond to, you don't want to, I would advise not responding to it, not answering questions that are raised at a public comment period, because then you could engage in conversations about matters that aren't on your agenda. And you haven't provided the proper notice to discuss that you're going to be discussing that, so that other people who may also be interested in it haven't been given the notice that you're going to discuss it, and that they could come up and come to the meeting and discuss it also. So during the public comment period, people can speak, set a time limitation. They can speak for the certain number of minutes allowed, and then no further discussion. If somebody addresses something on the agenda, once you hit that item on your agenda, then of course you can talk about it at that point, but I wouldn't address comments or questions during the open comment period. So boards and commissions, as I said, they serve a couple of different roles. Some are advisory, and you're just going to be holding public meetings to discuss matters within your jurisdiction. Some boards are going to be holding public hearings, and those are your regulatory boards or advisory. I guess the one exception to that would be the Community Preservation Committee, which holds a public hearing before it makes a recommendation to the City Council. There are different requirements for public hearings and public meetings. Whatever your public hearing, whatever your statutory requirement for holding your public hearing is going to be specific to your particular board. If you're on a regulatory board, such as the Historic District Commission or the Planning Board or the Zoning Board, it's important to understand if you have rules of procedure that pertaining to your public hearings, then to familiarize yourself with those and to make sure you follow those. The hearing is conducted to provide due process to an applicant. It's important that everybody have the ability to address the board. It's also important that opponents have ability to address the board, and the board makes the determination, the decision as to whether or not to grant or deny a permit or a license on the basis of what is presented to them during a public hearing. And so that's the information that's contained in the record. So that's important to make sure when you're holding a public hearing that you do it in a manner which allows people to speak and also focuses on the documents and evidence presented. Here's a slide that tells you about conducting hearings. It's generally in the same process as a meeting. The chair controls it and opens the public hearing, gives the proponent an opportunity to make a presentation, gives an opponent the same opportunity. Again, when you start having public hearings where there are a number of people who want to speak, it's important to set the time limits, how long each speaker is going to get to be given the ability to speak. You also cannot control their viewpoint. So if somebody comes up during a public hearing and is adamantly opposed to something, and they're using language that maybe seem very critical and inappropriate, is not uncivil, I guess you would say, the chair does not have the authority to ask them not. It has the authority to say, please be civil, but you can't stop them from being uncivil. You keep the public hearing open, and you can close a public hearing, and then the board undertakes its deliberations. In some instances, if you think there's going to be an opportunity to, once the deliberations continue or take place with the Board of Commission, you think you may have some additional questions for the applicant or from the opponents or proponents, then I would recommend keeping that hearing open during the deliberations, and then you don't have to reopen a public hearing. So if you keep it open until you've finished your deliberations and you're ready to take a vote, then you don't have to worry about reopening it or providing additional public notice if the meeting is continued to another date. So in terms of decision-making, remote meetings require a roll call vote. Permit granting authorities require a roll call vote. And advisory boards in person, if you're all in person and you're making a recommendation, you can vote by a show of hands. All boards and commissions are required to take minutes and adopt those minutes at each of your meetings. The minutes must include the date, time, and place, members present, summary of discussion, and list of documents discussed, and names of the members of the public who speak. The minutes have to be adopted by the board or commission, and that's typically required within the next 3 public body meetings, the next 3 board meetings, or within 30 days. And those minutes should be adopted and filed with the city clerk's office. Those minutes become a public record and are available for public records request. Leading us to the public records law. The Secretary of State's office has a very good public records law website that includes the guide to public records law. It's very up to date. It also has decisions on public records law and will help you. If you have any concerns about what's a public record and what's not, what you have to keep, it's a good place to look, and it will help you understand what it is. So public record law. So one of the reasons we're going back to the fact that public records, the purpose for them is to make sure that we have an open and transparent government. Any type of document that you're considering that you create as a public official in your capacity as a public official, like an email to somebody, a letter, or a text, can even a text between members or between applicants about matters that are within the jurisdiction of the board and commission, those are also considered public records. And they're subject to public records requests, which I'm sure that everybody is familiar with, because that becomes an issue. And I would assume that most members of the boards and commissions have received emails occasionally saying, please provide all of your emails about this topic because we've received a public records request. And that typically comes from the city clerk's office. One of the important things is to note is that the Secretary of State's office and the public records law has a public records retention policy. So it tells the city how long we have to keep certain materials. So if you create a public record, if you send that email out, if it's through a city email, it's going to be stored on our server. A lot of boards and commissions do not have a city email, and we recommend that you create your own separate email address just for your membership as a board of commission, like a Gmail account or something that's for your board of commission, and communicate, have all that flow through that email account. And then when you have a public records request, or you get to a point where you need to provide information, you have it in that one very easily accessible account, as opposed to trying to filter through your own personal email account. Because unfortunately, you know, as a public official, you never know what's going to happen. That's part of the sort of the interest of being a member of a board or commission, because a number of different issues come up and you never know when someone's going to say, did you write an email about this issue 3 years ago? Can I have that? And if you have it in a separate account, then it'll be easy for you. You won't have to worry about whether you still have that email address or whether it's intermingled with your personal information. So public records requests can come in, so they can come in verbally or in writing. What we do is we filter them through our next request system so that we can keep a record of those. We have to respond to public records requests within 10 business days of receipt. If you have, if a public record request comes in that's relevant to your board or commission, you'll receive a note or an email from the city clerk's office asking you to provide those records. It's important to respond to those because you do have an obligation to respond and provide the public records that are required, that have been asked for and are required. There are exemptions to the public records law, though, and because we work closely with the city clerk, who is the records access officer, and the legal department works closely with the city clerk, and we'll look at public records requests to make sure that they comply with the public records law. It's got to be a specific request for a public record. It can't be the request can't be a general can I have all the information on something, on, some topic? Or you can't, a public records request doesn't ask people to create a document either. It's got to be for a specific public records. And we review those requests and will object to, provide a response to the requester as to whether or not it complies with the law, or if they're asking for a public record that is exempt from the process. And so the next topic is the state ethics law. Again, the Mass government has a great website for the conflict of interest. It's the State Ethics Commission. And if you have questions about that, it's a great resource. There's lots of forms, there's FAQs that will really help you understand your obligations under the state ethics law. And the other thing is that all boards and commission members must take state ethics law training. They've recently changed their training process, and it's much easier for everybody. When you are appointed to your board or commission and you're sworn in by the city clerk lets the State Ethics Commission know, provides the commission your email address, and then they will contact you and provide you with information of taking your online training. Within 30 days of being sworn in, that certification that you've taken that training is kept on file with the State Ethics Commission, and also the city clerk gets a copy of that. So we know that everybody's up to date and in compliance with the law. You have to take that training every 2 years. Once you take your initial training, you take it every 2 years. And it does help you. One of the things to be aware of with the state ethics law is that it's a personal obligation. It's not a municipal obligation. So it's you as an individual. If an issue about your personal compliance with the state ethics comes up, that is something that you have to deal with as an individual. It's not something that the city steps in and sort of handles for you. So that's something that I feel like always makes everybody say, okay, I'm going to take my online training and I'm going to know exactly what it is, and I'm going to be very careful, because that's an important thing to do. So as boards and commission members, you're considered municipal employees and subject to the state ethics law. The state ethics law sort of regulates your conduct while you're in office and after you're in office. There's certain restrictions on what you can and can't do while you're in office. There's an important aspect of the appearance of the conflict of interest. So you want to make sure, what you always should think in the back of your mind, would a reasonable person think that you're being improperly influenced in your decision-making process? That's the question that you should be asking yourself. And in most instances, state ethics law isn't an issue, but there's always the possibility, right? It restricts and forbids bribes, as we know, self-dealing. You can't use your official position to give yourself a benefit, or your members of your immediate family a different benefit that somebody else would not be able to use, and that you have because of your official position. It also restricts nepotism, gifts and gratuities, false claims, and using your confidential information. Working a second job incompatible with your city position, that's really for municipal employees. It's not really for boards and commissions, and having a financial interest in city contracts. Saying all that, in Gloucester, most members of board and commissions are special municipal employees, which means that that under the state ethics law, you're treated differently. You have more leeway than an actual city employee. We have all the boards and commissions that are special municipal employees. They're listed in the city ordinance, and they're also listed in a handbook that the city clerk's office has. So the difference is that when you're not a special municipal employee, you can't act as an agent for anyone other than your, in your capacity as a board or commission member. But when you're a special municipal employee, you can do that. So you don't have to worry about that restriction. You can also have a financial interest in contracts made with the city, as long as there's a full written disclosure, and you would disclose that to your appointing authority. That would be the mayor. And in most instances, the mayor would then make a determination as to whether or not you could continue to act in your capacity without being unduly influenced. And there's a State Ethics Commission website has a number of forms that are required to be filled out in different instances where there could potentially be a question about your conflict of interest in matters that you have that are within your jurisdiction. So that is something to look at if you have any questions. Also, if you have any questions, please feel free to contact my office. We will provide opinions. We will also, there's also a lawyer of the day at the State Ethics Commission. You can call them. You can talk to them about your concerns about your own personal obligations under the state ethics law. They're happy to help you with that. It also protects you in instances where you can say, well, I did contact the state ethics law and state ethics commission, and I was given this advice. So that's an important thing to consider if you have any questions whatsoever. As I said before, you are obligated to undergo the state ethics online training. And that's a certification that you'll get once you go into that training, and that will be given to the city clerk mayor's office that you have complied with that. And that's always, it used to be that the city clerk would contact you and ask you to do it, but now it's all done through the state. And I looked at the website today, and it looks like it's a pretty easy, accessible website to use. So don't be worried about it, and please comply with the state ethics law. And so that concludes, it's a general overview that I've given tonight that concludes this portion of the training. And so now what I'd like to do is open this up for questions for anybody. If you have any, I'm happy to answer them. And again, if you have any specific questions that relate to your board or commission, you can always give me a call. The law department telephone number is there. There's my email address, and Chris Brosnahan is the assistant general counsel. And he is also available to answer any questions.
So if you have a question, you can raise your hand, and I will make it so that you can talk. I think there, Suzanne, there is one question in the Q&A from Chuck Shade. I don't know if you can see that.
Okay.
It's right next to the participants.
Okay.
On the.
So shall I read the question?
Yeah, I think it's.
I think I'll read the question for everybody. I don't know who can see it, or just make it easier. So Chuck asks, if you haven't already covered this, can you clarify situations where it is appropriate for a member to recuse or abstain from voting, and the importance of those who have not recused to vote rather than abstain? So I think, so I'll sort of talk about this generally as to what it means to recuse or abstain. And this goes back to if we go back to the state ethics law, if there's a matter that you feel that you can't, for a number of reasons, that you have a conflict with, or there would be an appearance of impropriety, and you can't sit on the matter that's before your board or commission, then you would recuse yourself. And then when you recuse yourself, what you do is you don't participate at all. You don't engage in the conversation. You don't act as a board member. You recuse yourself at all. And then I think what Chuck is then asked is once, if a number of board members recuse themselves, you have to make sure that you still have a quorum to be able to consider the matter. And then if other board members then abstain, go through the conversation and abstain, and then so many abstain that you don't have enough to make a decision, then that becomes problematic, right? Because then your motion is going to fail if you don't have enough people to make a decision. So if you're going to, so I think my advice would be, in most instances, if you're going to abstain on a matter that's before your board and commission, then I would do that at the outset. You're giving the applicant, the benefit of knowing what the outcome is going to be. Because one of the things as boards and commission members, I'm sure you hear all the time, is people are frustrated by the fact that they have to even ask for a permit to do certain things. The regulatory process is frustrating to some people. It's very important for everybody, until you're the one asking for the permit. But so it's important that when an applicant comes before you for a hearing looking for a permit or license or a decision, that if members of the body are going to recuse themselves or abstain, let the applicant know in the beginning. Give them the opportunity. Applicants, when they come before you, are coming before you with the sort of their right to be heard by a full board, a full contingent of your board. If you don't have that full contingent of your board available to make that decision, give an applicant the opportunity to continue the matter and come back when a full contingent is available.
All right, let's see. We have Robert Gula. Go ahead, Robert. You should be able to unmute yourself and ask a question.
Yes, thank you, Suzanne, for this. Can you hear me?
Yes, I can. Yep. Thank you. Yep.
One thing I keep dealing with on conservation is we'll go through a hearing, we'll talk about a project, we'll open and first we'll open and close the public comment period, and then we'll start talking about the topic. And then somebody in the public screams out or starts going and bringing it up again after I close the public comment period. And we get stuck in this area of saying we can't talk about it anymore. We've closed the public comment period. But is that all I can say at that point? Because sometimes they just keep going.
So I can see that would be a problem. So once the public hearing process is closed, so the chair controls the meeting, and people can only speak at a meeting or a hearing if recognized by the chair. And one of the ways that to handle that is to make that known at the beginning of each public hearing, is to actually make that statement and be very clear about when people can participate. And then when you close a public hearing, before you close a public hearing, you can say, this is it, we have no more input from the public. And if it becomes too disruptive, you definitely want to let people know that they're being disruptive, and you ask them to stop speaking.
Okay, but I can't reopen anything, correct?
No, you can't reopen. Well, so my advice is, if you're holding a public hearing, you get to the deliberations and you think people are going to want to talk again, and we're going to want to hear what they have to say, then don't close your public hearing while you're undertaking deliberations. But you can then pause and say, we're in the middle of deliberations. You pause and say, oh, do we want to have some more public input on this, and take that additional public input in, because your public hearing is still open even though you're in deliberations.
I understand.
But if you've closed your public hearing, then you can't, you'd have to reopen a public hearing, which is problematic.
Understood.
Right? Because then you have to do the proper notice, because people who, once they hear, oh, they've closed their public hearing, I have more to say, but it's closed, I can't say anything more, I'm leaving, and I'll hear what they decide at the end, right? You want to make sure that everybody, sort of the test for proper notice is, if a person wanted to object to something, have you given them proper notice that the matter is going to be discussed? That's what the court looks at when they go and they say, was proper notice given?
Thank you.
Yep.
All right, we've got Finn. Go ahead, Finn. You can unmute yourself and speak if you'd like. You're still muted, Finn. I'll give you just a second more if you. There you go.
My question is regarding the appointment and reappointment of chairs and co-chairs to boards and commissions. I'm wondering if this is actually how these reappointments or appointments are undertaken, whether it is strictly at the pleasure of the mayor, or is there a public input or commission or board input, and as regarding the chairs of these commissions?
That's a good question. So the different boards and commissions, as I said before, each board and commission is created either by ordinance or by statute, but even if you're created by statute, maybe some of the powers are brought into the city, and then there's an ordinance created. So if you look in your code of ordinances, any board or commission that we have sets out sort of the process, who the members are, what are how the composition of a board or commission, and it typically says how a chair is elected out of that. Some boards and commissions, the ordinance says that the mayor appoints the chair, and some ordinances say that the members of a board or commission vote to appoint a chair. So that's really going to depend on the specific board or commission. And my recommendation is, whatever board or commission that you're interested in and you have that question about, take a look at our code of ordinances. It's in most of the boards and commissions are located in one section of the code of ordinances, and it says boards and commissions, and you can just scroll down there. It's on the website, and look at all of the different rules regarding that.
Okay, thank you.
Yep.
Right.
I see one question in writing here that maybe I'll answer first, and that's it says, how much detail should minutes provide? So there was a slide on that about the minutes, how detailed they are. It's got to have all the members of the boards, all the members that are present, all the members of the public that spoke, a list of the records, documents that were considered and at the meeting, and it has to have the votes taken and the discussion. So it's not a verbatim transcript of a meeting, but it is enough so that somebody can look at the minutes and say, oh, I understand what was discussed here. Here's the agenda item. Here's the discussion, the subject matter of the discussion, if any votes were taken. Here are the documents that were reviewed and discussed by the board members, and here's the vote that was taken. So it has to be enough so that you go back and you're creating a good record of what occurred at the meeting. Okay, now we'll go on to Linda's question.
Yeah, hi, perhaps I missed it. How long do we have to retain the public records, such as emails, correspondence, and other materials? Can you hear me? Okay.
That's a good question. So the public records retention guide, or the records retention guide, I believe it's 7 years, but it's good to check that schedule. I'd have to check that schedule for you. One of the things that I would suggest is, if you personally have emails that are related to your board or commission, is to provide those, like deposit them with the city, bring them to the city clerk's office, or give access to them, and so that you're not storing them, but they are city records, and that the city will go through and go through the process that's involved in destroying those public records when they can. And if you have an email address that's affiliated with the city, that's retained on the city's server, and that's retained. I mean, I would defer to Ryan, but I think that that's essentially in perpetuity until our server becomes forever, right? So forever. So if you have emails that are in your own personal, you can send them to the city, and we can retain those.
Okay, thank you.
Yep.
Yeah, that is one important note, Suzanne, for those who are, if you're leaving a board or commission and you kind of say, well, I don't want to just kind of and I've got a separate email address that, I don't want to kind of retain for 7 years or 8 years. If you contact either Suzanne or someone in the clerk's office, we can arrange to have you can essentially just send all of those emails to any city email address, and then those will just kind of be retained in perpetuity on our side. Then as long as that's kind of done, I would check in with Suzanne or the clerk's office prior to, don't just do it without unannounced, so that we are familiar with what they are and who they're coming from and what they're for. But that is one thing that you can do.
Yeah, I think I would agree with Ryan. That would make it easy for everybody. Then you're not, once you're no longer a public official, then you're not concerned with that. You don't have to worry about that anymore.
All right, let's see, we got Beverly.
Unmuted. Can you hear me, please?
Yep.
Yes, we can.
Okay. Thank you. Suzanne, your first question actually raised more issues for me. So I presume that you recuse yourself from consideration of an agenda item when you either have a conflict of interest or a perceived conflict of interest. Correct? Isn't that a reason you asked to be recused?
Yes, so if you have a conflict of interest, then you would recuse yourself from it.
Yes.
If you have the appearance of a conflict of interest, if you're concerned that you have the appearance of a conflict of interest, the best thing to do is to really look at that and to determine if there is a conflict. If there's not a conflict, what you can do is you can make that, you have your choice. If it's just the appearance, you can make a disclosure on the record at your meeting. You know, it could appear that I have a conflict of interest because of my relationship with so-and-so, but I want I want it on the record that my relationship with, so let's say it's your second cousin or something like that.
Yeah.
This person is my second cousin, but I believe that I can make this decision in an objective manner, and it won't interfere with my decision-making process. So you can do that, or you can just recuse yourself, and you don't have to give a reason. Once you recuse yourself, you don't have to tell people why you're doing it. You can just say, I'm recusing myself from this.
Okay, so I think that's clarification, because I think it's very important. But if you do recuse yourself, do you have to leave the room? Or can you sit and listen to deliberations but not participate? And in case of Zoom, I guess you would leave the screen and, come back for the next agenda item. I don't know, but it just seems it's not clear whether you physically have to remove yourself.
Well, so there's no requirement that you physically have to remove yourself, but the best thing, if you have to recuse yourself, then the best thing to do, if you're in a physical location, is just to get up and remove yourself from the table. You don't have to leave the room. You can go sit, in the audience or sit in another chair, and just, you don't want the whole notion of having the appearance of impropriety is if you're sitting at the table with your board and commission members, it looks like you're participating in it. People may feel like, oh, well, she's sitting there, so she's going to influence their decision. So it's best to get up, leave the table, sit somewhere else. If you're on Zoom, then I would say you don't have to leave the Zoom meeting, but shut your camera off, mute yourself during the.
Okay, presumably, so that people understand that you are distancing yourself from the discussion and decision. So I'm curious then, if someone recuses itself based on conflict, what are the grounds for abstaining? Which is something else you discussed in that question.
So the grounds for abstaining. So
yeah, why would I, if I'm not recusing myself as a result of having a conflict or what are the grounds for other committee members to abstain? Because you indicated that it's only fair to the applicant that they understand that they've got a voting majority. What are some of the grounds? I'm on the planning board. I rarely see anybody abstain from participating and voting. I'm just curious.
Yep, I agree with you.
Okay.
It is rare that people abstain. It's very rare. I think that people would abstain for various reasons, because maybe they just didn't feel comfortable making a decision on the case. They didn't feel like they had enough information, so they couldn't vote yes or no. There may be various reasons, but it's not, you don't abstain because of a conflict of interest, right? Because that's
right, because you've
abstaining,
already,
you're still participating in the matter.
Exactly.
So it's really that I would assume that a board of commission member didn't feel that they had enough information, or that they didn't feel comfortable in making a decision, so they would just abstain.
Okay. Now, sometimes one last thing, and I don't want to belate this, but it is that if you've missed a meeting and you missed a hearing, you can abstain because you haven't fully heard it. But we do tape all of our meetings, and presumably you can also listen to the tape and bring yourself up to speed, so that you'd have less reason to abstain. But you did distinguish between recusal and abstention, and I think that's important for those of us on the call today. Thank you.
Yes, and I think you bring up a good point, because if you're on a regulatory board like the planning board and you do miss a meeting, then you have that obligation. You can participate, but you do have an obligation. It's called the Mullen rule, right? And I'm sure you've heard this from your staff people, is that you do have the obligation to listen to the meeting and bring yourself up to speed. And I believe it's only one, and make a certification that you have done that. And I believe it's only one meeting that you can miss in order to participate in a matter.
Okay, thank you very much for those clarifications.
Yes.
We've got 2 in the Q&A section.
Okay. So I'll read the questions, and it's, I understand a list of the documents are recorded in the minutes, but where should the documents be stored that were reviewed? This is in terms of the committee, if that's any difference. So the open meeting law doesn't require that the documents be attached to, I'm sorry, I was reading Ryan's note. It doesn't require that those documents themselves be attached to the minutes. It's just that they be noted. And once they're a public record, then those documents become, so if you're a commission or a committee, then you would keep those in the commission or committee files. And these are the records that we looked at, and they're a public record, right? Once you look at a document at a meeting and discuss it, that document becomes a public record and is subject to the records retention law and the public records law. The next question is, how do we know if we need to renew our ethics test? Can't remember when I last took it. Well, the State Ethics Commission has a new online training process system in place, and they're going to be contacting board and commission members and tell you when you have to take it. So it used to be, right, we all had to remember and rely, or we would rely on the city clerk's office to remind us. Now you're going to get an email. This is one reason to make sure your emails are up to date with the city clerk's office, so that she can provide those to the State Ethics Commission, and they can, they will contact you and they'll give you a link to the training that's going to be personal to you. And that certification will then, as I said before, go to the commission, to the State Ethics Commission and the city clerk's office. And I think that's it. Is that all of our questions? All right. Well, thank you all for attending, and please feel free to give me a call or send me an email, or Chris an email, if you have any specific questions. So thank you and have a good night.